This video will present an introduction to Rule 404 of the Federal Rules of Evidence and its prohibition on the use of character to show propensity. Rule 404 prohibits evidence of character. 404A says that evidence of a person's character or character trait is not admissible to prove that on a particular occasion that person acted in accordance with the character or trait. In other words, you are not allowed to use character evidence to show propensity. What do we mean by character? Well, some examples are Old Chief is a violent person, Sally is a drunk, or John is a law-abiding person. Character can be either good or bad. 404 prohibits that kind of character to show that they did something on this particular occasion. So because he's a violent person, we can't use that to show he's more likely to have committed this violent crime. 404 also prohibits evidence of specific crime, wrongs, or acts. So in addition to evidence that someone has a particular character, you cannot use evidence of a previous crime, wrong, or other act to show their character, to show that they acted in accordance with that character. Importantly, 404B only prohibits evidence of these acts to show propensity. Such prior acts may be admissible for another purpose. Some purposes are listed for you here in 404B, but these are not exclusive, and 404 allows such evidence for any other purpose, as long as it is not to show action in conformity with a particular character trait. We'll discuss some of these other possible purposes: motive, opportunity, intent, preparation, plan, etc. Also important to realize that on request, a prosecutor must provide notice of his intent to use other acts to prove other purposes under 404B. The defendant can be prepared then for a 403 argument, why that evidence should be kept out nonetheless. So 404B talks about specific crimes, wrongs, or other acts. Those specific crimes are not admissible in order to show the character of the person, in order to show action in conformity. So again, it's the character itself that is problematic. Using a previous act in order to show character, in order to show action in conformity therewith. What's often difficult is figuring out that this hidden propensity is there, that it's propensity evidence that you're asking the jury to use, because sometimes it sounds like you're admitting it for another purpose, when really what you're admitting it to show is that they're more likely to have done it because they've done something like this before. So the forbidden inferences are using these evidence of other acts to show character, to show action in conformity therewith, to prove someone did a current thing. Now, this obviously is tilted towards criminal, because that just seems to be the type of prior acts that we see the most, evidence of a defendant's other acts in order to show they did something charged. But note that character is inadmissible for any type of case, whether it is a crime, whether it is a bad act, whether it is before or after the particular event at issue, whether it's a civil or a criminal case, no matter whose character it is we're trying to introduce. And finally, 403 may result in exclusion even if 404 does not. So what you would first find is there another purpose for bringing in the evidence of the prior act? If you have another purpose articulated under 404B, then 404 will not keep out the prior act, but 403 might. You will do your balancing then and ask if the probative value of this evidence in proving that non-propensity purpose is not substantially outweighed by the risk of unfair prejudice, including prejudice that the jury may use that prior act for the forbidden purpose of character. So, what we're trying to do in avoiding the quote propensity box is finding an admissible other purpose. Evidence of the act, not to prove bad character, to show action in conformity therewith, but to prove something else, like motive, intent, plan, etc. If you have that other purpose, then it is not character, and you have not violated 404. You might, however, be excluded, the evidence might be excluded under 403. Some routes that we have discussed in class that avoid propensity include proof of knowledge. We saw a problem where a particular person had knowledge of how to hack into a computer system, and therefore showing that they had done this on a previous occasion was admissible to show knowledge of how to hack into that particular computer. We also saw in the People v. Daily clip that one argument for admissibility of evidence that the defendant said he had been in the military and he knew how to get rid of a dead body might show knowledge because the body of the current victim is missing. However, that's something that could very easily be outweighed under 403 because knowledge of how to get rid of a dead body is not as specific as knowledge of how to hack into a computer system. Finally, we saw in the train crash example that in a civil case, the fact that the train company knew or should have known that the conductor had been drunk on previous occasions and had a problem with drinking would be admissible to their knowledge of that fact, and whether they were negligently entrusting the train to him, whether they were negligent in hiring or maintaining his employment. Second, we've talked about proof of motive. In Peltier, we saw that evidence of the fact that there was an outstanding warrant against Peltier was evidence of motive in his shooting of policemen who were chasing him, unarmed or undercover policemen. In the presumed innocent clip, we saw that evidence that the defendant had an affair with the victim might be another act that comes in for proof of motive rather than proof of his bad character having an affair. Third, we saw proof of identity, and this is one that I think is most problematic because it's easily articulated, but often there is hidden propensity involved when you're talking about identity. In Peltier, again, the police found both Peltier's gun and one of the agent's guns in the van when they stopped Peltier. His gun could be brought in to show identity because it was the same type of gun used in this crime. The agent's gun, his possession of the agent's gun, could be brought in because the agent is one of the ones that was actually killed. So having his gun in your van shows your identity as the killer. The closer in time and circumstances between the acts, the more likely that they will go to identity as being instead just another way of saying propensity. MO, or signature crime evidence, requires very similar prior instances. In Trankler, we saw that the previous bombing was had a lot of earmarks as being the handiwork of the same defendant. If that's the case, then it's like a special identity argument. It's not just that it's more likely that this person did it, it's that it is more likely that anyone else, it's less likely that anyone else could have done it because it is that person's MO. Other routes include res gestae. We said where the particular evidence comes in to explain something so that the jury understands the other facts better. They're inextricably intertwined. In the Russian roulette example, the jury was able to hear that the defendant had pointed the gun at the witness's head so that the jury could understand better and believe better her story that she remembered seeing this specific gun several years previously. In U.S. versus DeGeorge, evidence of his prior insurance claims was admissible to explain why he couldn't get the insurance in his own name in this instance and had to go through a series of security transactions and different company formations in order to get the insurance. Another example is absence of accident. For this purpose to apply, the defendant needs to be arguing that it was an accident. Evidence that the defendant claimed the same accident previously is evidence that it's less likely it actually was an accident because his behavior would have changed. Had this man actually killed his previous wife while he was cleaning his gun, we all think that he would be a lot more careful cleaning his gun in front of his second wife. Finally, the doctrine of chances is a little bit different from absence of accident because the doctrine of chances is something that is so unique, it's really not possible that it would happen this number of times. Instead of it being an accident that the defendant claims, the defendant is claiming that something happened by chance. And if there have been a number of other instances just like this, then the doctrine of chances says that it is less likely that it actually was chance and more likely that it was done by design. When other evidence does come in for another purpose, when you have successfully articulated that non-propensity purpose, then what is the proof of that other act coming in? So in the brides in the bath case, we are able to admit proof of a previous bride dying in her bath. What is the standard of proof of that? If our defendant was never convicted of that prior crime, then how do we show that it actually happened? What the court said in Huddleston is that this is an issue for the jury. And so long as a reasonable jury could find by a preponderance of the evidence that the defendant committed the other act, then the judge should submit this evidence to the jury. The judge does not herself weigh the credibility of the evidence or make a finding that the defendant committed the act. The judge simply examines it and finds, could a reasonable jury find that this happened? In Huddleston itself, the other act was that the defendant had sold stolen goods on a previous occasion. The defendant said that the government couldn't prove that those previous televisions were actually stolen, and the court said that the standard was not beyond a reasonable doubt or by clear and convincing evidence. Instead, the standard was, could a reasonable jury find that the televisions were stolen by preponderance of the evidence? So 104 deals with such preliminary questions about admissibility of evidence and conditional relevance. Under 104A, which deals with whether a witness is qualified, whether a privilege exists, or whether evidence is admissible, the court itself decides whether that evidence comes in. This is a preliminary question for the court outside the hearing of the jury. Instead, if we're talking about relevance that depends on a fact, conditional relevance, Then, proof must be introduced sufficient to support a finding by the jury that the fact does exist. So, could a reasonable jury find that this fact does exist? What the court said in Huddleston is that proof of this other act that we have found evades the propensity box because we have another purpose for it, proof that it actually happened, which is what it's dependent on. It's conditional relevance because only if it actually happened is it relevant. If that's the case, then all that's required is enough evidence that a jury could find it by preponderance. The court may conduct a hearing so that the jury cannot hear the arguments of the parties about whether in fact this evidence does come in.